Here we go. Not legal advice. Like, subscribe, share, comment, show pets. I know usually dogs, but I've heard elephants also. So if you have an elephant at home, please show your elephant. As promised, I would do a video on the Alpine oral argument that happened today in DC, in the DC appellate court. And that's regarding Alpine, which involves GTII. Alpine was the prime broker for GTII. Many people believe that if Alpine went down, that would impact GTII's stock positively. Not financial or legal advice. I have no idea, but we've been following, myself, and others have been following the status of legal proceedings involving Alpine. Today's proceeding was the oral argument in the appeal of Alpine in the denial of the injunction by the federal court to the expedited expulsion proceeding. In other words, Finra was trying to kick out Alpine on an expedited basis after 35 years, and Alpine got an injunction or tried to get an injunction in the lower court, was denied. It was granted on appeal. And this appeal is of the lower court's denial. So I hope that is confusing enough, but that's the issue, not anything beyond that, but whether the judge's denial of the injunction was proper or was it abuse of discretion, etc. Of course, before I start, although I just started, so I don't know how I could say that, but I said it anyway. I had a few brief remarks, and I'll add a couple more of these at the end. I had a pun I was going to do about amnesia, but I forgot how it goes. I'm designing a reversible jacket, and I'm so excited to see how it turns out. To the guy who invented Zero out there, thanks for nothing. And we'll have a few more of those remarks at the end. So, Alpine's appeal today involved, indirectly at least, FINRA's authority in enforcement actions and their legal authority. And so the relative positions are FINRA thinks it's allowed to do what it wants to do in enforcement actions, and Alpine Scumbags, as you know, Alpine prime broker, history of dozens of convictions or admissions of liability or responsibility violations of the Bank Secrecy Act, try to get a admitted sex offender as their representative with the regulators, numerous misappropriation claims, etc. They're the ones who are appealing the denial of the injunction. They also have an action. They filed a civil action against the SEC, challenging the SEC, challenging FINRA's authority to proceed. In that underlying civil action, that's where they filed and sought the injunction. So there is a pending action that's still ongoing. This injunction, though, tried to stop the expedited proceeding, which was designed to expel FINRA. So I hope that clarifies nothing, but I hope it was an attempt. So, in a just to kind of give you how it was set up, there's a 3-judge panel and an appeal. They will have been presented briefs to read, which they will, or their law clerks will have. They may have generated some type of decision. Mostly appellate work is to analyze to see if there's errors in law. Generally, they're not deciding the facts. They're accepting the factual record is correct. So Alpine and FINRA and the government and a bunch of other parties filed briefs in this matter. So I listened to the entirety of this extremely boring oral argument. It was on the East Coast, so I was in my office at about 6:15. The oral argument, I would say, went about 2 hours. 3 parties. So one was Alpine. They were represented by counsel, and one attorney spoke for them. I would say, including questioning by the appellate judges, approximately an hour, maybe more. A lot of questions for Alpine, I would say, because there's three parties, they seem to get the most of the questions. They were the ones who are the appellant. They're the ones who are appealing, or yeah, they're the ones that are appealing in this case, the denial. And they're the ones who contest the legitimacy of FINRA to do anything, which many of us agree with, even though we think Alpine are scumbags, which I certainly do. So, three-judge panel. Uh, Seemed like Alpine got the majority of the questions. Secondarily, FINRA, when they spoke, so FINRA had their own counsel. When they spoke, they got a decent amount of questions. So if I said Alpine was an hour, FINRA might be 30 minutes. And then somebody for the government spoke also, maybe 15 minutes or so about that. And so I would say hour 45, about hour 45 approximately. That was how it was kind of broken down. If I was going to make a prediction, I would say, as to the issue, the issue being, should the injunction that was denied, should we uphold the denial of the injunction? I think the decision should be yes, because to withstand that, besides they have to show a likelihood of success, and there was confusion as to whether they could as to this matter. And they also have to have clean hands. In other words, they have to have acted in good faith. And even though the hearing really didn't address that very much, it addressed likelihood of success a little bit, but not the bad faith of Alpine. I don't think they're going to comply. And I think the easiest thing for the court, and this is a little bit of a cynical view, here we have somebody asking the court to review the denial of an injunction. A lot of people go in for injunctions, and injunctions are denied and granted. And generally, they're not reviewed, or if they're reviewed, they're mostly denied. So, if in fact this particular tribunal reversed the denial, they would be inviting a lot more appeals, probably, and a lot more work. So, if my cynical side says, just from a practical standpoint, they wouldn't overturn the denial just for that reason. So again, the specific issue on appeal was the denial of the injunction related to, and it's even more specific than that. This is not even an enforcement proceeding. So we're talking about where FINRA is going after one of its members. This was an expedited expulsion proceeding. So it was different than a normal expulsion period where expulsion proceeding where people would get notice, have a lot of time. Here, movement was fast. Now, again, it was fast, although Alpine's been in business since 1984. So how fast is that? But when FINRA and the SEC finally decided to act, it was quick. And so the fact it was an expedited expulsion proceeding is relevant, and the court did focus on that. And any ruling that they would give would be limited to that expedited expulsion proceeding, which means that the benefit to Alpine would be very limited because there'd be other ways of extracting Alpine from the system. So the basic argument that was made by Alpine, it's the same argument that's made in other cases, are two. The appointments clause, which means that the hearing officers, per the Constitution, should have been appointed and the ability to get rid of by the executive branch of the government, the president, etc. So the hearing officers theoretically should be appointed. And the SEC, I think the administrative law judges are. So they do comply with that. But FINRA does not. But FINRA is also not the government because it's a SRO. And to be governed or controlled by the appointments clause of the Constitution, you have to be a part of the government. And there was a lot of argument or discussion about whether, in fact, a SRO is in fact part of the government. And I believe they probably are, in my view. But for this purpose, it doesn't seem like that's a view that would be accepted by this court based upon the discussion. So that being the case, so the fact that these hearing officers are appointed by FINRA probably is not fatal in that respect. But there's a secondary test, and that's the non-delegation doctrine, also a constitutional doctrine, which means you can't delegate, the government can't delegate important government functions. In this case, it would be applying securities laws with FINRA without the government closely supervising that non-governmental agency. So then in this case, it would have to be the SEC supervising FINRA. And the question is, does the SEC do an adequate job of supervising FINRA? And that was kind of discussed. And it was also discussed that, in essence, uh, FINRA cannot exclude somebody from the business. All they could do is exclude somebody from membership of FINRA. That doesn't mean they couldn't conduct business of a different nature or in a different country. And some of the judges, especially the one who was asking the most questions, seemed to be impressed by that fact, that it was only membership, not being completely kicked out of the business, even though there really is only one regulator that is involved, and that's FINRA, who's in essence designated by the SEC. And what's interesting is, apparently in 1983, there was a law passed that required there be an SRO acting in a capacity like FINRA. So FINRA and its predecessor was created by, in essence, congressional law. Although, and this was important as the judges state, unlike other SROs, the government did not create FINRA, nor did it finance FINRA, nor does it pay the employees. And some of the other SROs, that happens. So the court was interested in that because the more contact between the government and the entity, the more it looks like the government. So they were distinguishing FINRA, at least in this context, they were distinguishing FINRA from the government. So if it's not the government, then we don't have an appointments clause. Then, in terms of non-delegation issue, it's a matter of whether the SEC was adequately supervising FINRA, and there were arguments back and forth about that. There was an argument about what happens if the court grants or holds the lower court's ruling, so it sustains the ruling, doesn't overturn it, and FINRA goes back, continues its expulsion proceeding. What would happen? Because the question to the Alpine attorney was, well, what's your downside? What's the harm? And they had to acknowledge the fact that they still would have an appeal to the SEC. And even though an expulsion is effective immediately, you can also apply for a stay. And there was an occasion already where Alpine had been expelled. It was somehow overturned or pending. They went in, they filed the document, and 2 days later, the stay was provided. So the suggestion was, if they apply for a stay, that they will get a stay, so they won't be out of business. And Alpine's position is, if you let this go and they conduct an expedited proceeding and they find against us, we're out of business because it'll take us time to get a stay, and then we'll whatever. And the real facts were, it doesn't take very long. They probably would get a stay. So probably what would happen, if Alpine lost, they would apply for a stay. Stay would probably be granted. There would be a hearing in the SEC. If they lost that, they would appeal that to the federal court, and that would be the end. But at some point in time, if they lose a proceeding like this current appeal, and especially if the judges reference the bad faith conduct of Alpine, again, this is just a death march, and it just determines when the death march occurs. From the tone of the judges today, it seemed more like a discussion of the greater issues, because some of these issues might come back in front of them in another proceeding, or this proceeding in another matter. But it didn't seem like the injunction proceedings itself were that complicated or were encased by the constitutional arguments. And again, because it was very narrow, we're just talking about an injunction as opposed to the constitutional right of FINRA to conduct its business. And obviously, the difference of opinion was whether the SEC provides adequate review over FINRA, because if they don't, then there could be an issue of the non-delegation doctrine. However, my practical reasoning still applies that the judges don't want to encourage denials or grants of injunctions to be heard by overturning those rulings. They were also interested in, and I thought this was an interesting point, in terms of whether they were trying to figure out what kind of remedy they could impose. How could they get FINRA to protect rights where there was an expedited expulsion proceeding? And they talked about, could you require, and it would require like the amendment of bylaws of FINRA. And there was a discussion of whether you could do that, but it sounded like very onerous. So to get the remedy, again, in a very narrow circumstance where there's an expedited enforcement proceeding, the judges seemed somewhat skeptical, in my opinion. Also, it was interesting, this tells you how active FINRA is with the thousands, maybe tens of thousands of brokers. Apparently, as of now, there is only 24 enforcement actions that are ongoing in all of FINRA. So with all the scumbags out there, only 24, and we don't know what state they might only be actively litigating one or two. That's completely improper. That's suggesting they don't have the manpower to adequately run enforcement, which kind of leads to the MMTLP situation where they acknowledge they can't keep track of the number of shares outside the country. So they can't do enforcement, or apparently they can't do enforcement in a reasonable and timely manner. They don't know the number of shares. They can't vouch for dilution. It doesn't seem like they can do a lot. And I think I tweeted this morning, and I think it was discussed in the proceeding, that SEC could get rid of FINRA's officers for poor performance. So Mr. Cook, who I think has done poorly in MMTLP, apparently could get canned by Gensler. Now, whether he does that or not, I don't know. But anyway, the bottom line is a lot of discussion about whether it was governmental action or not. I think the judges will find, for purposes of this case, it wasn't. I think they will say that the stay is adequate to protect Alpine if there's a expedited expulsion proceeding that goes against them, but that they can still get a stay, so they won't be out of business unless they lose the appeal in front of the SEC and then either decide not to go in front of a federal court and seek the same injunction, probably denied, or if they do. So that's what I think. So if that makes sense. So I think the court will uphold the denial of the injunction of the lower court. That's in favor of FINRA and against Alpine in this particular proceeding. That's my view. Hopefully that makes sense. And if it doesn't, please ask me questions, put in the comments, and I'll try to answer them. It was quite a lengthy oral argument. The briefs were substantial, and I think I mentioned there probably were about 15 friends of the court briefs from various parties. And the court did distinguish FINRA from the other entities that filed briefs, again, because it wasn't established specifically by the government, just that the government required SROs to exist. But the other entities that actually filed briefs were actually established by the government, may have been more directly funded, etc. So again, if that doesn't make sense or you have questions, please let me know. 60 days will be approximately to get a ruling. Based upon the ruling, I will advise you what will happen next. In the meantime, I'm hoping the SEC and FINRA go into federal court tomorrow and shut down Alpine. They can do that irrespective of all this. I encourage them, and that's their duty and obligation, especially when they've indicated on multiple occasions that Alpine are scumbags, have committed violations, have put the public at risk. There's no reason they don't protect the public, and that's outside of the enforcement proceeding. That's just going into federal court, getting a receiver appointing, shutting Alpine down. I strongly encourage them to do that. I've done it multiple times. Maybe one day they will do it. I think it'll be a smart move, and I think it'll be well received by the public. And last but not least, after the birth of your child, your role in life will obviously become more apparent. And getting paid to sleep really would be my dream job. And last but not least, what's red and bad for your teeth? A brick. Anyway, I hope everybody has a great night. I hope that made some sense. If it did not, again, please, please, please put questions in the comments and I will try to answer it to make some semblance of sense out of this particularly exciting proceeding that happened today. As to all of you out there, thank you for joining. Be well, take care, and I think we're done.